Well, it is Wednesday and I am in the office. I am not in court today. This week's a little bit of an unusual week. A lot of judges take vacation this week, and we only have a few court appearances this week. And I'm not in court today. I'm just in the office in Morristown, New Jersey, getting things ready for another busy week next week for our clients in Pennsylvania and New Jersey. I did have a preliminary hearing on Monday, and I did put out a blog article regarding it. And that hearing brings up a good opportunity for us to discuss preliminary hearings and what your attorney should be doing during them and the strategy going into those hearings. In this particular case, our client was charged with a felony of the first degree, that being burglary, as well as criminal trespass and some misdemeanors. Now, a tactic that the district attorney's office frequently uses in a lot of counties, including Philadelphia, Chester, Montgomery, and Delaware, and Bucks, where our law firm frequently practices, is trying to convince us to waive, us being the defense, to waive the preliminary hearing in exchange for dismissing the lower grade offenses. So in this particular case, our client, in addition to the burglary, was charged with simple assault, possession of instrument of crime. And really, the case is about the burglary and the criminal trespass, because those are the felony offenses, and those subject our client to a possible state prison sentence, even though she didn't have any prior criminal history. Now, a lot of people may think that the offer to dismiss charges in exchange for waiving the hearing sounds like a good offer. You were originally charged with 6 counts, and now you're charged with only 2. But really, the meat of the allegations are those felony offenses. So in this particular case, we rejected that offer to waive the preliminary hearing, went forward with it, and were able to have the felony charges dismissed for lack of evidence. Now, the misdemeanor charges were held for trial, but the case is now far less serious. Remember that a preliminary hearing is not a trial. The goal there is not to establish whether or not, well, the goal for the prosecution isn't to establish a conviction or get a conviction. It is simply to establish enough evidence, that being prima facie evidence, to hold the case for trial. So our goal there was to, well, really threefold: to collect information, set the case up for trial, and also to have charges dismissed or downgraded. So we were able to accomplish all of our goals at the hearing. It was a very successful hearing. Our client is now in a great position to really do a great job at trial, and I believe be exonerated at trial on those lower level offenses. But if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. The website, gambonelaw.com. As always, a tremendous resource for you and your family. All of my books, my blogs, my videos are available there in one convenient format. We answer our calls 24 hours a day, 7 days a week. So once again, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. Please enjoy this week responsibly. Please don't drink and drive. If you are stopped for suspicion of DUI in Pennsylvania or DWI in New Jersey, do not refuse the chemical test. Be polite, be respectful to the officer. Do not give consent to search your person or your vehicle. Have a great day, and I'll talk to you all very soon.